Hello everyone, Andrew Bethel with the Bethel Law Corporation, and we are an estate planning law firm located in California. Now, being an estate planning firm, we do have a couple big practice areas in our office, one of which is probate cases. Now, we are of the opinion that our clients should avoid a formal probate action through the proper funding of a living trust, but we understand sometimes things happen and an estate does have to go through probate. Now, if you are involved in an estate that does need to go through probate, you should not fret. There are some advantages through going through probate as opposed to going through a living trust. And today we'll be discussing those advantages. Now, this video is intended as a companion piece to our probate overview video, where we do discuss a typical probate process in California, but I will discuss a little bit as to what probate is before we get into those advantages. So, probate is just the legal process of passing title to one's property down to the next generation. It typically involves court oversight over the process on just about every aspect of it. So there will be a manager who is the person who needs to go through and consolidate the assets, close down accounts, sell off assets, etc. The court will approve who is going to operate in that capacity and will oversee the accounting before any distributions to beneficiaries are made. Now again, if you want more details, you can see our probate overview video, but that should be enough to just get you a general idea before we get into the potential advantages of probate. First, supervision of creditor claims. So in California probate court, creditors are required to make a claim on an estate, and they have to do so within a certain time period. Now, the supervision of those claims comes under the court's general supervision of the probate action itself. Because the court oversees the process, they are not going to allow creditors to kind of get away with a lot of different things, because creditors have to make sure all of their paperwork is done correctly, all of their I's are dotted and T's are crossed before they can get anything under the estate. Additionally, the manager, whether they be the executor or administrator of that estate, does have the authority to negotiate those creditor claims. So with that, the court provides oversight of that negotiation and makes sure the creditors aren't trying to do anything sneaky on the estate. Next, I kind of alluded to this a moment ago, and that is the limited creditor period. So in California, creditors are limited to at least a 4-month time period in which they must file a claim on the estate or be forever precluded by law from collecting on that estate. So it essentially limits that time period of which those creditors can climb out of the woodwork and make a claim on the estate. Having that limited time period is great because it creates a definite cutoff point that cuts off those creditors from coming back and causing issues later on, especially once things are ready to be distributed or have already been distributed. Next is another advantage that falls kind of under the court's general supervisory powers. Since the court is overseeing the whole process, that means they are also supervising the distributions to the beneficiaries. The manager of the estate cannot make distributions to beneficiaries without court approval. And that typically comes after that manager has had their accounting of the estate approved by the court. Now, the accounting must be provided before any distributions can be made, and must also be provided if the probate action goes on for longer than a year. So at that 1-year timeline, the administrator or executor of the estate, they have to provide an accounting to the court, and they also have to explain where they are in the administration process and essentially why they're not done yet. So with that, the court is going to supervise any distributions being made and won't allow those distributions to be made until that administrator or executor has dotted all their I's and crossed all their T's and all their numbers add up to the bottom of the accounting. So they have to prove that they have administered the estate correctly before they can even distribute anything. And again, all that is under the court supervision, and that means you need a judge's approval and stamp of approval before anything can be distributed. Finally, the last advantage isn't really in regards to the probate action itself, but having a court involved might help keep the peace in the family. So because there is court supervision over the entire process, it does provide a peace of mind to the beneficiaries that the administrator or executor or manager isn't going to be running off with the money. There is oversight over to their actions and approval of their accounting. Additionally, if there are challenges to the administration of the estate or challenges to any provisions of the will, we immediately have court oversight over those challenges. So that means we have a judge there to determine whether the will is valid or not, whether a particular provision in the will is valid or not, or just to kind of help diffuse situations where parties think there is some malfeasance going on. With that, that does mean the process can go along a little bit more smoothly because there is that court and that judge there to cut off the complaints and help the process move along. Thus, to summarize, while we do typically recommend avoiding a formal probate through the proper funding of a living trust, if you are involved in an estate that does need to go through probate, there are some advantages to that process, mainly in the form of court oversight over the creditor claims, the limitation of that creditor claim period, court oversight over any potential distributions, and meaning the court is also going to look at the accounting before those distributions can be made. And then finally, the court will help keep the peace. Essentially, you have a mediator there to help solve disputes over any provisions in the will or any actions undertaken by the manager of the estate. The judge can render a ruling and help the process proceed along smoothly. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.